That's 10, 9, 8, 7, 6, 5, 3, 2, 1, 0, and liftoff.
Attorney Andrew Myers here on the About the Law channel. We're talking about the Massachusetts Supreme Judicial Court order and decision in the Karen Reed case. Yolie Medina, thank you for joining me today.
No problem. Glad to be here.
I kind of did a dirty trick on Yolie. I called her at the last minute and said, hey, can you help me with this? Can you help me with this? And she was nice enough to do that. I guess my first question is, somebody let us know we're on, because
yeah, it looks like we're on because there's people in chat. So
yes, I see them. Denise from New Hampshire, from beautiful cold New Hampshire. When I got up this morning, it was like about 6 degrees outside. How's the weather out there in California, Yolie?
it's gonna rain. It's real cloudy. It's about 59.
Yeah, we've been getting snow. We had snow last week on a Thursday, and then again on Saturday night. Then we're going to get it again. It's like Groundhog Day. We're going to get it again on Thursday of this week, and then again on Sunday. So I don't know anything else. So the Massachusetts Supreme Judicial Court has come out with its order rejecting Karen Reed's appeal on several grounds, which I question.
Right.
But why don't we just jump right into it? We didn't play our intro, so here we go with that. So thank you, folks, for joining us. Feel free to ask us questions. We'll try and get to them. But Yolie, here it is.
Wow.
This is the 35-page decision. We don't really have to read the whole thing because a lot of it is just rehash of what happened in the case. And I think that if we have any viewers, to the extent we have any viewers, our fans have been following the cases. But right off the bat, I'm going to point something out that I was disappointed with, and that is that there were 9 Supreme Court justices that heard the case, and there are their names right there present, and all 9 signed off on this decision. Not a single one dissented. I found that disappointing at the very least. What do you think of that? Anything?
I find it disappointing, and this also looks like it was written on a typewriter. It looks like typewriter font.
Well,
I mean, I don't know, but yeah, that's disappointing that there was no dissenting opinion. But I figured as such, because once the jury leaves, the court, it's kind of hard, and maybe from now on they're going to want to. I mean, lawyers are going to want to poll the jury just to make sure.
Now, Yolie, you just told me you didn't read the decision yet. You just encapsulated it in those 3 sentences. So, thank you, folks. We're all
psychic. Psychic.
I just had a chance to. I was working on I don't know if I could show the viewers. My conference room table is full of papers. I was working on a federal case in which, a document is due on Thursday. So I was cloistered into my conference room, working on federal court papers that absolutely positively have to be filed on Thursday. So I didn't even know this happened until I came up for air at lunchtime, and there it was. Other people were talking about it, and so I just read it very quickly. So we're pretty much in the same boat on this. We're not going to read the whole thing because it's 35 pages, and again, a lot of it was just a rehash of what happened. But why don't we jump right in? One thing that's interesting before we jump in, the prime appellate attorney was Martin Weinberg. And here's a statement that he put out today through Boston 25 News. Ted Daniel is the reporter who did an interview with Karen Reed, which ran right after the Super Bowl. They promoted Ted Daniel's interview with Karen Reed during the Super Bowl, which, as you know, that's got the biggest audience of anything in TV. it's Christmas to the TV stations. And so he interviewed Karen Reed. He's been following the case. And this is a statement, apparently, he spoke to Martin Weinberg, quote, "While we have great respect for the Commonwealth's highest court, double jeopardy is a federal constitutional right. We are strongly considering whether to seek federal habeas relief from what we continue to contend are violations of Ms. Reed's federally guaranteed constitutional rights." Martin Weinberg, attorney for Karen Reed. So I found that interesting. He's considering it. We're not there yet. Oh, I think the reason that it looks like it was typed on a typewriter was that it is what they call at the very top a slip opinion. So it can be modified if there are, grammatical errors or formal errors. I mean, they're not going to change their mind, but the attorneys can say, hey, you said the case site was wrong or something like that. So nothing is going to change. So the defendant challenges the denial of her motion to dismiss after her first trial ended in a mistrial. That trial was lengthy, spanning 8 weeks of evidence involving 74 witnesses and 657 exhibits. The defendant does not contend that this evidence was legally insufficient to support a conviction on any of the charges. No, that's obvious. No, that wasn't the point.
No, but yeah.
Instead, her argument focuses on whether the trial judge properly declared a mistrial in the relevance, if any, of post-trial accounts of jury deliberations. The jury deliberated for 5 days, sending progressively insistent notes. Now, that's hyperbole, insistent.
Yeah.
To the judge about their inability to reach a unanimous verdict. In their third and final note, the jury stated that some members firmly believed that the evidence surpasses the burden of proof, establishing the elements of the charges, while others did not. They described their views as rooted in sincere adherence to their individual principles and moral convictions. And remember, we talked about that.
Yeah. Their individual convictions, which are supposed to be set aside when they sit on the jury.
Yeah, we talked about that back last summer when this all happened, and it was troubling to both of us independently. We didn't even talk about this, but they also stated their further deliberations would be futile and would force them to compromise these deeply held beliefs. Based on this final note, the judge declared a mistrial. The defendant's motion to dismiss and this petition rely on post-trial accounts from several jurors. These accounts suggest that during deliberations, the jury unanimously agreed the defendant was not guilty on 2 of the 3 charges and were deadlocked only on the remaining charge. The defendant argues that a mistrial was thus not manifestly necessary because the judge could have requested a partial verdict from the jury before discharging them. The defendant further asserts that these post-trial accounts show she was, in effect, acquitted on 2 charges and that double jeopardy bars retrial on those counts. And if true, if the jury was unanimous on 2 counts, that is double jeopardy, the way I see it.
Well, yeah, I mean, it seems that way. It's just unfortunate that they left the courtroom and they were put in a bus and they were bussed away.
No, I have a problem with this paragraph right here. I know the judgment was I know the order was unanimous. All 9 Supreme Judicial Court justices agreed, no dissent, but I still have a problem with this. The petition thus raises the question, can post-trial accounts of jurors' private deliberations that are inconsistent with their public communications in court render the declaration of a mistrial improper or constitute an acquittal where the jury did not announce or record a verdict in open court? We conclude they cannot. But that's, when you go to law school and then you attend, continuing legal education seminars, which I've been doing for over 30 years, as I must, in order to get my license renewed every year, you learn that, you just went through a long trial. You feel that your client's rights have been violated, you're not happy, and you have, in this case, all these many weeks and exhibits and witnesses. And so we've all been implored to focus on the issue, tell the court exactly what the issue is that you want decided. But that's not what the court did here. That I just read what the issue is that they decided. But here's Karen Reed's appeal brief that she wrote or filed. There's Martin Weinberg, Michael Pabian, Alan Jackson. They filed this back on September 24th, 2024, and they did, as all good attorneys must do, they framed the issues. This is just a table of cases and all that good stuff that you have to do.
Yes, I remember.
Here are the issues that were presented. Like I said, and I've been to this court, we all must focus. So here are the issues that were presented. One, whether the jury's final unanimous agreement following trial that Ms. Reed is not guilty of counts 1 and 3 constitutes an acquittal for double jeopardy purposes and precludes retrial. Not exactly the same as what they decided.
What they decided, they said that deliberations, that the conversations within the deliberations were inconsistent with the note that was sent to the judge. That's not the issue.
So you and I have not even talked about this before. I played a dirty trick on you. I called you in the middle of the afternoon.
I know.
So we haven't even talked about this, but you agree with me. Okay.
Yeah.
Issue 2, whether Ms. Reed was alternatively entitled to a post-trial inquiry to substantiate her claim that the jury acquitted her of counts 1 and 3, and 3, whether there was manifest necessity to support the declaration of a mistrial on counts 1 and 3, where 1, the jury was not deadlocked and in fact had reached unanimous agreement on those counts. 2, the trial court provided no opportunity for Ms. Reed or her counsel to be heard regarding the declaration of a mistrial. And the court here just said, they didn't do it.
Yeah.
3, the record, and in fairness to the SJC, I'm not there, I'm down here. In fairness to them, they did address these 2 concerns in the papers. We're going to take a look at it in a minute, but again, the issues that were presented don't match the issues that were answered. The record reflects no consideration of alternatives to a mistrial when in fact such alternatives existed and were codified in Mass Rule of Criminal Procedure 27B. So let's go back to the decision. But the issue that they answered was, and notice there were 3 issues that they presented, and this just says this petition just raises the question, can post-trial accounts of jurors' private deliberations that are inconsistent with their public communications in court render the declaration of a mistrial improper or constitute an acquittal where the jury did not announce or record a verdict in the open court? So words are really important. We're not like carpenters or plumbers. I tried to fix a plumbing problem in my house. Oh my God. So we don't have tools. Our only tools are words. I can't
even operate the oven. So
our only tools are words, and we have been, implored to use them precisely. And so it's a little bit disappointing to see that the words of the petition and the issues that were framed were twisted around. Okay. The jury clearly stated during deliberations that they had not reached a unanimous verdict on any of the charges and could not do so. I disagree with that. Only after being discharged did some of the individual jurors communicate a different supposed outcome, contradicting their prior notes. Such post-trial disclosures cannot retroactively alter the trial's outcome either to acquit or convict. Accordingly, we affirm the trial judge's denial of the motion to dismiss and the defendant's request for a post-trial juror inquiry. So I think we can skip over all of this because this is just the background that we've been through a number of times. The only thing I will read is that there were 3 charges against Karen Reed: M in the 2nd degree, manslaughter while operating a motor vehicle under the influence of alcohol, and leaving the scene of a personal injury resulting in death.
Now, I don't remember. Did she say they had to be unanimous on all 3 accounts, or just that they had to be unanimous, period?
Well, I don't remember what she said, but you have to be unanimous on all 3, correct?
Well, you could be unanimous on 2 and not on 1.
True.
Right?
Yes. So let's
So-
skip this. I'm sorry. Go ahead.
Yeah, so I was just wondering, I don't remember either, but whatever the case was, the jury left, and that was the problem.
So let's go down. Okay. Do you want to read a little bit?
Sure.
I shouldn't have all the fun. Let me know when you're done, when you don't want to read anymore.
Okay. On July 8th, 2024, 1 week after the mistrial, the defendant filed a motion to dismiss based on these post-trial accounts. The defendant argued that the accounts showed the jury had effectively acquitted her of counts 1, murder in the second degree, and 3, leaving the scene of a personal injury resulting in death. She further contended that the judge's mistrial declaration was improper for these 2 counts and requested at a minimum a post-verdict inquiry to confirm whether the jury had agreed she was not guilty of those charges.
And the next thing.
You want me to keep reading?
Sure. Yeah, the highlighted stuff.
Oh, okay. Yeah. The Commonwealth also submitted a post-trial filing notifying the court that after the submission of defense counsel's affidavits, it had received 2 voicemail messages from a member of the jury. The jury specified that the jury had voted not guilty on counts 1 and 3, and as of the last vote, 9-3 guilty on the lower level manslaughter charges. The Commonwealth also received email messages from 3 individuals who identified themselves as jurors and asked to speak anonymously. Once the Commonwealth informed them that it may be required to disclose the substance of their communications to defense counsel or to the court, however, the jurors declined to communicate further. The trial judge denied the defendant's motion to dismiss after a non-evidentiary hearing. I guess non-evidentiary hearing means they didn't have the jurors come in to testify, right?
Yeah, the Karen Reed's attorneys filed the motion, and they just came in and argued it on the briefs. They just there was no evidence. Although that's not entirely true. They did. Alan Jackson and David Yannetti and Elizabeth Little did append affidavits as to the 5 jurors.
Oh, that's right. Yeah.
That said that it was unanimous on counts 1 and 3. The jury was unanimous on counts 1 and 3. Count 2 is the one they're talking about there with the 9-3 vote or whatever it was, and that based on that, at the very least, they wanted the judge to bring back the jurors to poll, and they went out and they went out and they wanted to. At the very least, I think that the judge should have brought them back. I'm just looking to see. We do have a few questions, not a lot of questions, but we do have some people watching us, which is nice. Hashtag Hank. I live in the cesspool of Norfolk County and am not surprised. Thomas T says, has Norfolk always been this bad? Kirk 71 says the 4-person, got to go back. The 4-person determined that he was the gatekeeper and it was his decision alone. If notes be sent to the judge, that is not his job. He does not overrule anyone else in that room.
No.
I don't know about that.
Okay. You want me to keep reading?
Do you want to, or you want me to pick it up?
No, I'm fine. I'm fine.
Okay, great. Thank you. Whoops. What the heck did I do now?
I don't know. You pressed the button.
I pressed the wrong button. There we are. I'll keep my hands off of stuff.
Okay. The judge reasoned that because there was no open and public verdict affirmed in the open court rendered in this case, this defendant was not acquitted of any of the charges, and that any post-trial voir dire of jurors would involve an impermissible inquiry into the substance of the jury's deliberations.
Well, we have seen that in other jurisdictions. Okay, here we go. Go ahead.
Okay. Discussion number 1. Propriety of declaring a mistrial. The double jeopardy clause of the 5th Amendment to the United States Constitution generally precludes the Commonwealth from trying a defendant more than once for the same offense. And that's Commonwealth versus FIM 462, Massachusetts 470, and it's a 2012 case. And then they also cite Benton v. Maryland, 395 U.S. 784, 1969 case. And those hold that federal double jeopardy clause applicable to the states by the 14th Amendment. However, an exception to this general rule applies when the mistrial is declared due to manifest necessity. Citation omitted. Ray v. Commonwealth, 43 Massachusetts 1-3, a 2012 case. That's what's cited. In such instances, the double jeopardy clause does not bar the state from retrying the defendant.
I just feel that they probably cherry picked some of this case law because you know what? It doesn't, my gut tells me, people often ask, what does your gut say? My gut says this is wrong. My gut says that if in fact 12 jurors did agree on counts 1 and 3, it's a tremendous exercise to try this case all over again. Even if it was only on count 2, I don't know. It doesn't seem right to me.
It doesn't seem right either. And I feel like the jury was rushed out of there. Like they didn't have a chance, like there was no chance to do anything. I remember we saw it, and I think we saw it together, and the judge just said, that's it. And it was like, there was no room for objection. No, it was just kind of cut short. But
yeah, it was. And in my haste to get this episode together, I didn't go back and get that video footage that we did play it. We saw it live, and then we replayed it several times last summer. And, it was actually cited in the footnotes of Karen Reed's brief. And I remember the note was read by the judge, and she said, I'm not going to do that to you. I'm declaring a mistrial. Then the camera swung away, and she dismissed the jury. And Jackson and Yannetti and Little had no time. I don't care what anybody says. They didn't have any time. You don't speak up to a judge. You don't speak back to a judge. When you're in open court, you don't say, hey, Judgey Poo, hey, wait. No, you don't do that. And then the only thing that happened after that was scheduling. And the way Judge Canoni addressed that in her decision was, well, there were no shrinking violets during the trial. She kind of swept that concern aside. And I wish I did have that video, but it's there. Maybe we'll play it in our next episode. But
okay. So, and let me read. A hung jury has long been recognized as a traditional example of manifest necessity, allowing retrial without offending the defendant's double jeopardy rights.
Isn't that kind of circular logic? You need to have manifest necessity, but hung jury is manifest necessity. That, to me, yes, I see that they cited some cases there, but it just seems like circular logic to me.
Yeah. And then it says that the decision to declare a mistrial is entrusted to the sound discretion of the trial judge, which there could be an abuse of discretion by the trial judge. And I don't know if this was that that kind of thing, but it wasn't raised for this purpose. But
yeah, they get into that. If these principles were followed and there is no claim of insufficient evidence to support a conviction, double jeopardy will not prevent the defendant's retrial. Again, I think it's circular logic, because if these principles were followed and there is no claim of insufficient evidence, that wasn't the point. The point wasn't. But the point wasn't that there was. Although, right, it's not part of the argument. Although, they had the Supreme Judicial Court was given the full docket of the trial court, and there were, in fact, motions to dismiss and a directed verdict, and that's what a directed verdict is all about. The motion for a directed verdict says there's insufficient evidence to send this to the jury. Of course, it was denied, but that's not. First of all, it's not really the issue in this case, and second of all, it's not entirely true.
And then the footnote that you just passed.
Yeah.
It says, where is it? Okay. The defendant has not argued that the evidence presented at her first trial was legally insufficient to sustain a conviction, and we thus do not address the issue. Well, they keep talking about it. That's
not true. They again, they filed a motion for directed verdict, and a motion for directed verdict says that the Commonwealth or the prosecutors have not provided sufficient evidence.
Right.
So that footnote's wrong. Anyhow, again, a lot of this is just background. Do you want to read or should I? Doesn't matter. Okay, go ahead. Thank you.
Nonetheless, the defendant argues that the judge should have inquired whether the jury had reached an agreement on any of the charges. Had the judge done so, the defendant asserts she would have discovered that the jury had agreed on counts 1 and 3, allowing for a partial verdict. We disagree.
Oh, yeah, this gets to the reason I only highlighted one word. This gets to something we talked about last summer. And I don't know if you remember. I remember kind of, sort of. But Mass Rule of Criminal Procedure 27B says the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. So I remember saying back then, yeah, it's permissive language, may, but it would seem to me that what's implied is that, and maybe it's dangerous to infer things, but it would seem to me that that implies that that's the better practice, that it would be the better practice to ask the jury, what about counts 1, 2, and 3? But that wasn't done.
Yeah.
So the way, and there's 9 judges versus me sitting here in my office. And they found law. However, a judge is not required to accept a partial verdict before declaring a mistrial. And there's a 2004 case, which I didn't read before we did this episode, and not only that, is prohibited from doing so on a single indictment that contains lesser included offenses. Well, I'd have to see the context of that decision. I don't think our audience wants me to go run out and get the law book and read the case.
The law book. You're with the books.
Yeah, context is important, and I don't know. Here okay. I always say the important stuff is in the footnotes. Right. So I'll let you start reading when we get to the highlighted part. But as the trial judge observed in her memorandum of decision denying the defendant's motion to dismiss, it is particularly striking that the jury notes provided no inkling of agreement on any of the charges. Additionally, the notes did not request clarification on whether a partial verdict could be returned. Well, maybe they didn't know. This absence is particularly significant given the evident care that went into writing the notes and how articulately they expressed. Okay.
Jurors' disagreement. Yeah. Right. Okay. In fact, the jury's third note implied they were deadlocked on all charges. That note stated in part, some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charge beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. Okay. And then, as one court has observed, allowing post-trial juror counts to affect the analysis would create endless confusion and controversy in cases where a mistrial has already been declared due to deadlock.
I think it's the other way around. I think that just following what happened after the judgment in this case, I think there is endless confusion and controversy that could have been clarified had the jurors been brought back, as has been done in other cases.
Didn't they do it in the Ashley Benefield case?
Yeah, they did it in the Ashley Benefield case and the ballerina case and the Alexander Murdoch case. Yes. They did. Of course, I'll be told and chided that, oh, you're just one attorney in Massachusetts. Those cases were in Florida and Georgia where the law is different. Yeah. Granted. But still, there was already endless confusion and controversy. To this day, we hear confusion and controversy. People are on both sides of the issue. If you watch YouTube, there are people stridently taking one side or the other. The Supreme Judicial Court has sided with those that say, hey, as you said in the very beginning, you called it, if it's not read in open court, it's not a judgment. And that's what this ruling boils down to.
Yeah, that's interesting.
Yeah.
Since the foreman, the jury foreman, acted like he was in control, and he was the one deciding whether the notes would go to the judge or not. I mean, I wonder if that's misconduct on the part of the foreman.
A lot of people have said that. A lot of people have made comments along those lines. People question. I mean, usually the general practice is that at the end of the trial, the jury selects their own foreman. In this case, the judge said, this guy's going to be the foreman.
Yeah.
And a lot of people may have asked a lot of questions about that and said,
I mean, I don't know if the foreman juror thought it was misconduct, but I'm saying that it could be looked at as misconduct. I'm not trying to say he committed misconduct. I'm just saying that what he did might constitute misconduct, even though he may not have known he may have been mistaken as to his role.
Yeah, I'm trying to remain objective here. I'm trying to remain as objective as possible. It just seemed a little bit shaky that the judge appointed the foreman, and a lot of people say there were connections between the foreman and family members, and
we don't know.
Yeah, so
interesting. Things that make you go,
Yeah. Okay. Let's go back to the. Did I mention in the beginning that Lainey couldn't be here today? She had other things to do, and if I failed to mention that, because people always say, "Where's Lainey? Where's Lainey?" She wasn't able to do this this afternoon while we're recording this, but she did help set it up because I'm totally inept when it comes to. So she set it up, and that's why we are here. People say. Yeah, Darcy says, and she's talking, I'm sure, about the foreman. She's all the way at the top. I got to bring her back. Yeah, I wonder why Bev picked him. Look up the cases they cited. Commonwealth versus Roth is particularly noteworthy. I will, Honey Pot. Maybe you could look it up for us and get back to us. I just didn't have time this afternoon. I got a mess on my conference room table, also, the foreman was picked before the jurors were excluded randomly. Eileen Taylor, IRC 71, Saws for getting your name wrong. I don't know.
There's Lainey. Lainey's here.
There she is. Hi, Lainey. Hi, Lainey. You can join us if you want. Thanks for setting us up. Yeah, Lainey, if you want to come in, we'll let you in, no problem. But okay, so where did we leave off? In short, the record before the trial judge suggested complete deadlock. The first and second notes provided no indication of a partial consensus, and the third note plainly implied the opposite. I think they're reading too much into that. Where the jurors have twice reported themselves deadlocked and have already heard the Tui Rodriguez charge, a judge's inquiry concerning the partial verdicts cannot avoid communicating to the jury that the judge's desire to salvage something from the trial. However, the inquiry is articulated or explained. The import of the inquiry is unmistakable. Can't you at least decide a part of this case? I think that's wrong. I think this is the wrong context. That's not what it is suggested under Rule 27 that should have been done. What's suggested that could have been done as a better practice under Rule 27 that the judge may have said not. Can you going forward, but have you in your last 7 days? That instruction would not be telling the jury what to do or asking the jury to do something going forward. It's simply asking them, what have you done? So I think that this case cite out of Roth is misplaced. The inquiry by its nature plays on the deadlocked juror's natural sense of frustration, disappointment, and failure. I don't know about that. The jurors are confronted with the request and asked to absorb its inherent complexity at the worst possible time, when they are tired, anxious to be discharged, and perhaps angry at fellow jurors whom they blame for fail. This reads too much into people's minds. I always am upset when people say, You're thinking this. No, I'm not. Don't tell me what I'm thinking. And that's what this quote from Roth is doing. It's saying what they think. It might be true, but we don't know that. That's the point. We don't know that. That's surmises, and that's assumes, and that's not good. Statutory prohibition on ordering further deliberation was designed to prevent jurors from being coerced into reaching a verdict in the face of views conscientiously again, I hate to repeat myself, so I'll try and say it in different words. I'm not sure what the context of the 1982 case was. I don't know what the statutory prohibition specifically refers to. And let's remember that statutory construction has to be precise. So ordering further deliberations is not the issue here. Ordering further deliberation was not what would have been done under the May language of Rule 27. It would simply have been, did you reach a verdict? Have you reached?
Can you agree?
Yeah.
Have you agreed on any
Right.
of the charges or something?
Right.
Yeah.
Would merely be the product of one hasty final attempt. What they're talking about here is salvaging some part of the trial with one hasty final attempt. And again, no, all they would have had to have done is not send the jury back into the room to do something hastily, but rather just poll them. That's all. So I don't know. I think from the very top where this decision, unanimous as it may be, recasts the issue, rewords the issue, where words are our only tools as attorneys, and we are implored to be precise in crafting our issues, where the SJC kind of rewrote it. I don't know. Indeed, if the judge had inquired about a partial verdict on her own initiative and the jury returned a verdict of guilty on any of the counts, there is no question that this defendant would be making a strenuous and potentially meritorious argument that guilty verdict was the product of coercive intrusion into the function of the jury. Again, not the issue here. For much the same reason, the trial judge's decision not to poll the jury sua sponte to confirm the deadlock before declaring a mistrial did not constitute an abuse of discretion. So that answers your question before, where you said, well, they have wide discretion, but how do they determine it? So they, that argument that we were just reading answers. So the Supreme Judicial Court in Massachusetts decided that no, she was well within her discretion. When the third note prompted the mistrial, defense counsel neither objected nor expressed any dissatisfaction. They didn't have time. This is when that camera panned away. So the camera panned so fast when we replayed it, there was a trace on it. Do you know what I mean?
Yeah.
It wasn't a smooth.
And she just walked away, didn't she, to take the jurors? She told the jurors, go to the room and meet me there or something.
The videographers in the audience will understand what I'm saying. Where there's a nice, smooth pan from one part of the room to the other, it's nice and smooth. When they do it quickly, it's jumpy. And when we replayed that a couple of times, I redid it. I re-looked at it and redid it and tried to, slow it down. But they did it so quickly that it was jumpy from the time she read the note until she said, I'm not going to do that to you folks. I'm declaring a mistrial. And then the camera went like this, and it was so fast and jumpy. So again, in my view, I'm only one Massachusetts attorney, and there are 9 SJC justices who are way above my pay grade. Trust me. But I have a right to disagree. And I disagree that when the third note prompted the mistrial, defense counsel neither objected nor expressed any dissatisfaction, even when the parties remained in the courtroom they weren't given a chance. They weren't given a chance, in my view.
That's how I saw it too. And that's scary, because once they're out of the courtroom, that's what creates the problem. I mean, the getting them back in and testifying, it sounds like the judge has a lot of discretion whether to do that or not. And she didn't do it. She didn't think she would. She just didn't do it. She said, nope. There was no indication. And
one of the quotes in the brief that was written in that motion to dismiss after all of this came out was the jurors were whisked onto the jury bus because they were parked at some remote location. And some of the jurors looked at each other. What just happened? What just happened? Do they realize that we voted for acquittal on 2 of the charges? What just happened? So even the jurors in the affidavits that were filed and in the motion that brought all this about were acknowledged that they were rushed out of the place, given the bum's rush out of the Norfolk Superior Court, which I'd want to get out of. That's a different subject. So as discussed, the receipt of the third note barred the judge from requiring further deliberation without the jury's consent because they had already engaged in due and thorough deliberations and twice reported being deadlocked.
But it's not about requiring them to further deliberate. It's about whether or not they reached a verdict on any of the charges, not go back and deliberate. It's the question should be, did you agree on any of the charges? Did you agree unanimously on any of the charges? Were you able to agree on any of the charges? And they keep saying, well, to force them to go back and deliberate. Well, that's not the issue.
Exactly. I agree 100% with you. We didn't even talk about this. I played the dirty trick of contacting you and said, hey, Yolie, you available? You said yes.
I haven't even read it. I haven't.
But we both agree on this. And you and I have disagreed on some stuff before. But this, it's just, I don't know. I will probably regret what I'm going to say right now. But this was pending over the holidays, remember. This was initially argued in early November before Thanksgiving, and then it was pending over the holidays. And I'm not going to say anything more, but it was pending over the holidays. And now here we are about 3 months after it was argued. And now I guess the holidays and the warm feeling you get from wherever you get it over the holidays is passed in the rearview mirror. And now we have this decision. So that's all I'm going to say. And I know I'll get nasty comments for that one, but while the more prudent course might have been to read the third note to counsel and provide yet another opportunity to be heard before declaring a mistrial, the trial judge did not abuse her discretion in failing to do so. So there it is.
So the trial court judge has a lot of discretion when it comes to this.
Yeah.
And
I think you said that last summer, if I remember correctly. I think you said that last summer, that's what this whole thing boils down to. It's why we're not going to read all 35 pages. We're already on page 24. But I think it all boils down to these 2 points. A, that in the view of the Supreme Judicial Court, they defined the discretion that the judge has. It does end somewhere, and it's got to be reasonable, but they cited a whole bunch of cases and said what she did may not have been the best practice, but it's well within her discretion. That's point one. And point two, as you said in the beginning, it is I forget what I was going to say. It is that it wasn't read in open court.
Yeah.
Those are the two points that this decision was based on. In sum, we conclude that the trial judge acted within her discretion in declaring a mistrial without first inquiring about a partial verdict or offering a defense counsel an additional opportunity to be heard. You know what thought comes to my mind here is that I don't know about California, but here in Massachusetts and New Hampshire, where I also practice, every year these people that publish the law books, try and force us to buy automatically these new rule books. Every year a rule book comes out, and when I first started practicing law, I was so intimidated by the whole problem. I bought it every year. I have a whole bunch of books around here of Massachusetts rules of court, New Hampshire rules of court. I don't know if they do that in California. I'm sure they do.
Well, we have an electronic library, so.
Well, now,
but you can do the books too. If you want.
Now it's all electronic. And as soon as it went electronic, I told the book publisher to go have a nice day. I'm all done because I have enough expenses with 2 offices. And but my point in raising that is that they change these rules perpetually. Not only would they come out with a new rule book, but a couple of months later there was a supplemental rule book, and a couple of months later there was a pocket part. If nobody knows what a pocket part is, after the rule book comes out, they changed a rule. So now here's a pocket part that you can buy for $10 now that we've mailed it to you, indicating that the rules have been changed. So my suggestion is that Mass Rule of Criminal Procedure 27 be changed to take that word may out of there and to say that, when the jury comes back at a deadlock and there's more than one charge, the trial court shall just poll the jury. No, don't send them back into the jury room and make them do anything.
Yeah, that's good for the legislature to consider because of this case specifically.
And it's not just the legislature, although you're right. There are rules committees.
Oh, rules committees, yeah.
Yeah, there are rules committees that sit around and
that's true. Yeah,
attorneys that have nothing better to do with their lives after they get off of work, they go and they sit around in Boston, or I'm sure Sacramento or Concord or wherever, and they sit around. Oh, let's change the rules. So, rules I hate to say how many decades I've been practicing law, but in the decades I've been practicing law, so many rules have changed. It's one of the many reasons I don't do family law anymore, because not only do they change the rules, they've changed the courts, they've changed this. They just, a new person comes in and let's change it. Anyhow, let's get back to this. I guess I've ranted enough. The third note implied the jury were deadlocked on all the charges. I don't know why I highlighted that. Under the circumstances, given the content of the notes and the fact that the defense counsel did not request a further inquiry, same point, engaging in one sua sponte risked coercing a verdict, same point. Thus, the judge appropriately exercised her discretion in declaring a mistrial based on manifest destiny. There's that manifest destiny argument.
Necessity. You said destiny.
I'm sorry. You're right. It's the end of the day. You're right. Thank you for, do you want to read this one?
The defendant's claims of acquittal?
Sure.
Okay. The defendant separately argues that she cannot be retried on count 1 or count 3, regardless of whether the mistrial declaration was proper. She contends that post-trial information from 5 deliberating jurors indicating the jury was deadlocked only on count 2 and had unanimously found her not guilty on counts 1 and 3 effectively amounts to an acquittal of those counts. Alternatively, she asserts that the trial judge abused her discretion in denying a post-trial inquiry to verify these accounts of juror deliberations. We examine each contention below.
Okay.
Claim of acquittal based on juror disclosure. The Double Jeopardy Clause of the United States Constitution prohibits retrial for the same offense after an acquittal. To determine whether an acquittal has occurred, we look to whether, given the operation of state law, the jury acted on their view that the prosecution had failed to prove its case. And they cite a case, McElrath, Supra, 96. Because this presents a legal question, our review of the trial judge's decision is de novo. Okay, so that means they're going to look at it brand new.
Right.
Then relevant here, the fundamental requirements for a jury's issuance of a verdict in criminal cases are set forth in Massachusetts Rules Criminal, page 27A, and Roth 437, Massachusetts at 786. Pursuant to that rule, a valid jury verdict must be unanimous and returned by the jury to the judge in open court.
Yeah, there's that language. This is the second major point that this whole decision is based upon. You're right.
And then it says, our case law confirms that a criminal verdict is effective only when affirmed by jurors in open court.
Yeah, the only verdict which can be received and regarded, this is just repetitive, I think, as a complete and valid verdict of a jury upon which a judgment can be rendered is an open and public verdict given in and assented to in open court as the unanimous act of the jury and affirmed and entered of record in the presence and under the sanction of the court. In other words, the distinction between informal agreement on a verdict and the actual return, receipt, and recording of a verdict in open court is central. Only the latter constitutes, I'm having a hard time reading today, aren't I? Yeah. Only the latter constitutes a final verdict of the jury on a criminal charge, We have consistently reaffirmed this long-standing distinction through our jurisprudence. In this case, it is undisputed that the jury did not announce a final verdict on any charge. Although the defendant has submitted affidavits claiming the jurors reached an agreement on counts 1 and 3 during deliberations, the only statements made in open court reflected the jury's inability to reach a unanimous verdict. As discussed, the jury submitted 3 separate notes to the judge. Boy, they keep coming back to that as though, you guys are stupid. We have to keep telling you this. As discussed, the jury submitted 3 separate notes to the judge indicating deadlock, culminating in a final note indicating that some members of the jury firmly believed that the evidence surpassed the burden of proof, establishing the elements of the charges, while others did not. All right.
I think there's a question for you on the super chat.
Is there?
Yeah.
Oh, you're following it. Where are we? Do you have to go up?
Yeah. From Microdots.
But they've done some really good work. There's Microdots saying, I can't thank you enough. I saw the wave of orders coming in. You're amazing. But he's saying that to Kirks, not to me. Okay, I can't take. So where's the question?
The question, I can read it to you.
Okay, please do, because I don't see it.
Okay. Andrew, have you ever seen anything like this case in your vast experience?
No. And I've been following Massachusetts. I'm not from Massachusetts originally. I'm from Pennsylvania, but I came up here to go to college many, many, many years ago. And when I first started following the news, 2 state senators, DiCarlo and McKenzie, were in jail because they were taking kickbacks. And I don't have to say alleged because they were convicted and they were thrown in jail for taking kickbacks from the award of construction contracts to build the Boston campus of UMass, the South Boston campus of UMass. There was a third senator who was suspected and he wheedled his way out of jail. But then over the years, there have been many, many, many crazy things that have happened in Massachusetts, including, if you want to watch a good Netflix, and we've talked about this before, watch Fixing a Drug Case. It's all about how there were 2 people that were having real issues. One of them was actually phoning up drug inspections analyses in the Massachusetts State Police crime lab. She was actually, Annie Ducan was actually phoning up the analysis for drug cases. And after that came out, many, many, many people who had been convicted on drug charges were released. Their convictions were reversed. And I could go on and on and on about crazy things that have happened in Massachusetts. One thing which Turtle Boy has to get credit for is the overtime scandal in the Massachusetts State Police. Massachusetts State Police were putting in for all kinds of overtime hours that they didn't perform. And it's just, so Massachusetts has had many, 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 many cases that raise your eyebrows. But to answer the question, no, there hasn't been anything like this. There hasn't been anything like this case where, they're just, there's an expert. The 2 experts in ARCA said that Mr. O'Keefe was not backed into by a car, yet the Commonwealth proceeded to prosecute this case. We have all of the odd injuries to Mr. O'Keefe, obvious dog bites. We're not going to go into the 2 days of testimony by Dr. Russell when they tried to kick her out unsuccessfully, but those are dog bite injuries. I think even a kid can tell you that. And so we had to have 2 days of hearings where the Commonwealth tried to kick her out and the judge finally said no. So no, I've never seen anything like this. And I've been following Massachusetts since, the 2 senators being in jail. It's not funny.
Yeah. And
why do I laugh when I say it's not funny? And don't forget,
now that social media is an invention, people get access to information quickly, and it's easier to follow a case as opposed to like maybe 22 years ago, because I'm wondering if there are more cases like this that we just didn't know about or didn't come to the limelight because people didn't have access necessarily to whatever was going on. But I look at this case and it's clear to me, just based on what I saw, the evidence of the experts, of the prosecution's experts, they didn't meet the bar.
No, they really didn't. They really, really didn't. And, of course, there's going to be another motion to dismiss in their last motion, which was denied by the court, to pay for the expenses of the expert who flew all the way out from Arizona to Canton to look at the video. And then the video wasn't there. And it was obviously some kind of a miscommunication. But in that motion, on one of the very first pages, I think it was page 1, in the footnote, Karen Reed's attorney said, hey, we're pending filing a motion to dismiss based on egregious government misconduct. And so, I mean, it goes on. It goes on. It goes on. It goes on. So, I don't know. Have you ever seen anything like this in California?
No. I don't think so.
Yeah, it's crazy. Okay, so where did we leave off? We don't have that much more of this to go. In the absence of a verdict returned, received, and recorded in open court, we cannot conclude that the jury acted on their view that the prosecution had failed to prove its case. I don't know. The defendant argues that any lack of formality in the jurors' intended dispositions of counts 1 and 3 should not prevent those dispositions from taking legal effect. However, the requirement that a verdict be returned and affirmed in open court. See, there it is. Open court, open court, open court. We're closing our minds to the possibility of bringing the jurors back.
Interesting.
Yeah. Well, somewhere in here, there is a citation to the law in Massachusetts that says it's got to be something that's really improper, some kind of racial bias or other bias. And those are the grounds under which we bring back a juror. And none of those technical grounds were alleged or found in this case. But I mean, the law develops every day. And if there was ever a case to develop the law by an appeals course, in my view, in my humble opinion, this was it.
Yeah.
Do you want to read a little bit?
Yeah. Oh, yeah. Thus, because the jury did not publicly affirm that the defendant was not guilty of the charges, there was no acquittal barring retrial under the double jeopardy clause.
Oh yeah. Here's what we were just talking about.
But were they given the opportunity to do so? They weren't given the opportunity to do so because she didn't ask them if they agreed on any of the charges. Okay.
Yeah. This will answer the question that I was just kind of babbling about, why the court said, nope, we're not going to bring the jury back.
It says request for post-trial juror inquiry. Finally, we consider the denial of the defendant's request for a post-trial juror inquiry. Generally, a judge is not obligated to investigate jury deliberations unless there is evidence that jurors were exposed to extraneous information or demonstrated racial or ethnic bias. And they cite Commonwealth v. Faitu Hyang.
I don't know. Yeah.
2011 case. Even in cases of alleged bias, however, judicial inquiry cannot delve into the jurors' subjective reasoning or deliberative content.
Yeah. So that answers the question why this court says no, we're not going to bring them back.
Mm-hmm. Instead, she argues that the affidavits suggest an unannounced verdict warranting further inquiry. Yet, as discussed, a verdict as a matter of law requires a public announcement in open court. No verdict exists if none was announced or even intended to be announced by the jury before they were discharged.
Yeah, remember when we first started this episode, I said that was going to be a common theme, and there it is.
Yeah. Allowing inquiry into a private agreement reached in the secrecy of the deliberation room would also contravene our prohibition on probing the content of juror deliberations. Maintaining the secrecy of those deliberations is a bedrock of our judicial system.
Again, I think that skews the argument.
A little bit, yeah.
We're not really, please tell me if you disagree with this, but we're not really asking them to reveal the content of their juror deliberations. We're asking them to just simply tell us. And I think a question could be sharply worded, as it was in the verdict case. A question could be sharply worded and asked of each of the jurors, not the content of your deliberations. What did you consider? What were the prime factors? What were the holdout? No, just what did you think? What was your verdict? Did you acquit on counts 1 and 3? So I think, I don't know.
It's a hard one because, you got to follow the law. But at the same time, in my opinion, anyway, from looking at that video when she declared a mistrial, it seemed so like there was no room for anything.
No, there really wasn't. So we're getting to the end, folks. At least in my view, when the jury leaves the sterility of the court's control, contamination is presumed. Well, again, I'm only one private practitioner up against 12 unanimous Supreme Judicial Court justices who will probably call me on the carpet. But anyhow, we're not talking about the sterility of the court's control. Apparently, when they were on the bus being let out of the Norfolk County Superior Courthouse in Dedham down to wherever their vehicles were parked, that's when they said, wait a minute, what just happened? Did you ever do that? You walk in and out of a place and what just happened?
All the time.
So it's just, they weren't far from the sterility of the court's control. They were just on the bus, the right. Massachusetts trial court division's bus, big white bus.
But what I think it happened is when the affidavits were written, they were outside of the court's sterility and sterile environment. And especially with this case, it's so popular and so everybody's interested in it that it could be presumed that somebody might have gotten to them or something. But still, I just feel like they weren't given a chance. Like the whole thing happened in a manner that was so rushed, and you have to see it in order to understand. And that's the thing in court, you're just working with words, and it's.
Laney is yelling at me. Laney is yelling at me. The beeping is me telling him to check the super chats, and Ellie is telling me. Laney, I should say, is telling me a big channel. Microdots gave you a $5 super chat asking a question. Oh no, did I miss?
No, you answered it.
Okay.
That was the one about, have you ever seen anything like this in Massachusetts?
Oh, okay. All right, Microdots, we love your stuff. I mean, the production quality is outstanding and unsurpassed by those of us, as we've called ourselves, not you, Yolie, but Mark Betterow was on one day and he called us, including him and us, part-time grifters. But anyhow, we put these documents on the screen and we read and we offer our analysis, which I would like to think is worth something. But Microdots, some of the material that you've put out is just a high production quality way back in the days when I was in TV. Even then we didn't really approach the quality of some of the work that you have done. So thank you. So let's finish up. You want to read the last bit or should I?
You go ahead.
Okay. The jury chose to report a deadlock, not a verdict, and no basis exists for further investigation into private discussions or subjective beliefs they declined to announce publicly in open court. Conclusion: for the reasons stated above, the trial judge correctly denied the defendant's motion to dismiss and request for post-trial juror inquiry. The case is remanded to the county court for entry of a judgment denying the defendant's petition for relief. So that's it.
That's it.
And so there's been some talk in some of the YouTubeosphere about, these new Brady violations that are going to come up. And I'm not saying they're not serious. I think they're serious. But will they cause the trial to be pushed back? No, my view is that the trial is going to go on August 1st. That's just my feeling. What is your feeling about that or anything else about this crazy?
I don't know. I don't know. It just seems like, the prosecution was trying to trying to discredit the experts for the defense. And it's like, Isn't there such a thing as res judicata? I mean, they were qualified in the first trial.
Yeah.
You know, like the res judicata is like when it's already been decided that they're, you know,
Yeah.
I mean, I think it applies to cases, but that's the same concept. Is they were already qualified in the first trial, so why are you now trying to exclude them?
Yeah. Here's a comment from Larissa Harris. The judge in the Baldwin case didn't let misconduct like this go on. I don't get it. This is just common practice in Massachusetts, it seems. This is frustrating, truly. And yeah, the Alex Baldwin case, as soon as it was unveiled that the prosecution had withheld evidence, the case was dismissed. The trial ended. And, so that's true. Let's see. What else do we have? I live in Wisconsin, but so many people, Wisconsin, that's the land of making a murderer. I live in Wisconsin, but so many people love my framed stuff. Lots of great comments. Plus, I get to get free Karen Reed out to people here at Microdots. Okay. All right. Any other comments that we want to take a look at? Honey, what's so funny?
Thomas T says, I've seen Bigfoot videos that are more authentic than the Sallyport video.
Yeah, that's just incredible. That's just incredible. I mean, I don't see how any court on this planet can not have serious questions about not just the Sallyport video, which was just atrocious, but the fact that the video from the Canton Police Department video collection cameras and system, I imagine it's just one system with multiple cameras. How can little bits and pieces be allowed in where they're not produced before the trial? And how can Hank Brennan now say, "Oh, I gave him everything. I'll give it to him again," but they still don't have it. It was produced to them in bits and pieces, and as I said on a previous episode, snips and snails and puppy dogs' tails. How can that be allowed to happen where they don't just provide all of it?
Yeah, I don't know. This is strange how it seems like you can't get anywhere. It's like, you want to show the obvious, but yet it's just skimmed over. It's like there is a reason why they're fighting so hard to not give it up, even though they say on the one hand, well, I already gave it. I just gave it to him again. But they're not. You have to judge people by their conduct, not by their words. Yeah. Andrew, did you acquit? Is asking about the content of the deliberations. I disagree. We disagree. Did you acquit is not asking about the content of the deliberations. It's asking about the final result of the deliberations, in my view. Yeah, I think it's asking about the final result. It's not asking them, what facts did you use to acquit? What was the basis for your acquittal? Mass Dad says there are 7 SJC justices, not 12. I hate being corrected when I'm not wrong. Oh. Yeah, I hate being corrected when I'm not wrong. Here is the decision that was issued on February 11th, 2025 today. Let's take a look at the Supreme Court justices. 1, Budd. 2, CJ. 3, Gaziano. 4, Kafker. 5, Wendland. 6, Georges. 7, Dewar. 8, Wolhogian. 9, JJ. There were 9. 9. And they were, as I said in the beginning, I was just a little bit disappointed that there wasn't some dissent. But anyhow, people correct me all the time, and I'm human. I've made mistakes, and often I will fess up to my mistakes. I don't like being corrected where I'm right. Let's see. Risa Biller. I don't think I've ever disliked someone as much as I do Bev. It sickens me that she's in the position she's in. Oh, here's Twizzles. You know Twizzles, right? Yeah. Twizzle Stick. Seems like the state is protecting its own interests and doesn't want to get sued. I don't know. That's a hard one. Yeah. But you know,
I'm not going to read Nurms's out loud because I'm not going to read it, but there it is.
yeah.
Thomas T. Good point. I've never seen a judge ask the prosecutor if he wants to object. Yeah, remember that during the first trial? Somebody would make a statement and the judge would say, Mr. Lally, you want to object? I don't know.
Yeah, I mean, I can see if it was, you know, a auto accident trial and there was a brand new attorney that was trying the case and the judge is trying to help it along, you know, but not in something like this, a criminal case.
Yeah. I mean, even when I was just green with the ink still wet on my Massachusetts bar ticket. Yeah, they would be nice to you sometimes. Some of the judges would be kind of nice to you, but others, held you to even a higher standard than the good old boys. And I mean, good old boys, no apology, who had been before the judge 1,000 million times. And there's young me with still dark brown hair. And I walk into the courtroom and I felt that they held us to a higher standard. Most of them, not all, but most. Appears that the SJC disagrees with the trial judge's interpretation of the law. The language of tried together in 27B conflicts with 27A. I don't know. Mass Dad, you're right on this one. The court did agree with you on this one. Rule 27 permits judicial discretion.
Yes. And that's the big deal here is the discretion of the judge and the fact that they were let go outside of the court.
Oh, here's something. I'm sorry. Go ahead. I'm interrupting. Go ahead.
Oh, sorry. The discretion, the judge had wide discretion, and that was one issue. And then the issue was they were outside of the court when they raised these questions. Although they were they wrote affidavits that they were in the bus, but they wrote those affidavits after they were outside the court. So
right. I think at some point they I got the wrong banner there. I'm looking for a banner. They changed some of the stuff on here, and I get confused. What was I going to say? Here we go. If you are following us and you like us, please like. I put a new little watermark down in the right-hand corner, where all you have to do is click it and like. And please go to Yolie's channel. Yolie, what do you call your channel? Yolie Civil Attorney? It's
at Yolie Esquire, no period.
At Yolie Esquire. She, I can't stand these long podcasts that go on for 2.5, 3.5, 4.5 hours. I just, it's good. More power to you if you're able to do that. I'm still practicing law. I showed you my table before. I mean, this is what I was working on today when this ruling came on, and I've got to stay after school tonight to get done with that case. So I don't have time to give 2.5, 3.5, 4.5 hour.
I don't either.
But I like yours, Yolie, because my favorite word is pithy. They're short. They're to the point. You raise an issue, you give the facts, you raise what other people have said, and then you draw a conclusion. I really like your episodes that are like that, and I highly recommend them to people who, like me, don't like to sit around for 3 hours and watch something.
Well, I can do a live if somebody else is doing a live for a few hours. I can do that. But for me to do one on my own, I can't do that.
Yeah, I can't either. I had a cold over the holidays, second year in a row. Last year it was COVID. This year it was just a cold. And even to this day, it's getting a lot better. I can't talk for that long without my throat going out.
Yeah.
The doctor says there's a lot of that going around. New Hampshire, where I actually live, is number one on the respiratory illness list right now. And a lot of people that I know are having similar problems. But I'm fine. I did go to the doctors. I'm fine. But my voice gives out. But it's more the other thing that I said that, I just don't have the time. I mean, like yourself, I'm practicing law. I actually go to court. I had a hearing the other day. I've got papers to file. But anyhow, here's a point that I meant to mention at the top. And one of our people mentioned it, that Mark Betterow has joined the Karen Reed defense team.
Yeah.
Mark Betterow has petitioned Pro Hoc Vice to get in. And that is incredible. I mean, he makes the rounds of the podcasts. We have been lucky enough to have him come on our podcasts, and the man is just razor sharp. He's very articulate. He knows how to get to the point. He knows how to take the facts that are all over the place and put them together. And so that is going to be amazing to have him on the team.
The judge can deny his Pro Hoc Vice motion? I'm just wondering about that. I should look up the law on that.
I think that it's at the discretion of the court.
Well, isn't it the client's right to have what attorney she wants?
I would think so, yes. I mean, she already has great attorneys. And I think I've said it before. I think that Alan Jackson and David Yannetti and Elizabeth Little are top shelf attorneys, bar none. But I wonder if they're getting a little bit burned out. I wonder.
Oh, no, I know.
No? Okay.
No, I said, yeah, I know what you mean. I know.
Now, Robert Alisi is incredible. When he first signed into the case, I'm saying to myself, why is he signing into the case? Then when I saw him argue in the Russell motion, and then in the motion on Richard Green, the way that man puts together an argument is just, he's sharper than a tack. He's incredible. So, and he brought a new view to the case. He really was able to destroy Mr. Brennan's arguments on the Richard Green motion, whether there should be a voir dire with respect to Mr. Green. He just drove a tractor trailer over the arguments. And then, so I had at first wondered, why are they bringing him in? But now that question has been answered. And I already know why she wants Betterow, because the man is as bright as the sun. So anyhow, what else do we have? Microdots is having fun in our chat, which is fine. What, if any, evidence had metadata? I appreciate how down to earth Andrew's analysis is, and really enjoy your sense of humor. Thank you, Nexus Lexus, because every now and then we get a really nasty comment. So it makes up when somebody says something nice like that, and we try. And we also get a lot of crap because Lainey and I like to joke around a little bit, and we get crap for that. This is a serious case, which we know that.
Yeah, and sometimes you have to add some levity to it, because otherwise it just gets too much,
Andrew, what is your verdict on the 3 counts? I've said it before, without any apology, not guilty. I just don't see it. The Commonwealth case was a mess. It was a train wreck. The trial was a train wreck. There's too many holes in it. There's a ton of reasonable doubt in this case. I've talked about it before. I'm not going to bore.
Mine too. I didn't even see the whole trial, so I shouldn't really say, but just what I saw. I mean, the whole thing about Aruba, the fight in Aruba, it was like so remote and so unnecessary. I don't know.
Mass Dad, Andy, are you serious? Those are mistakes. Relax, kiddo. You wouldn't believe how relaxed I am. I feel like I'm going to fall. So, did anyone ever, at any time in their life, ever find that telling somebody to relax worked? Did you ever have an argument with somebody who you're personally close to, and one of them says to the other, "Relax"? That ever worked?
No. What you do is you lower your voice when they're getting upset.
A lot of feelings about Bev, none of them good. Della Sandor, judges ask for that verdict. Poor baby Lally doesn't know how to object to Mr. Jackson's questions. Did I say August? You're right. If I said August, I was wrong. Beatrice corrected me. See, I'm human. If I make a mistake, I'm willing to correct it. Yes, the trial is scheduled for April 1st. I know that. I have it written down. It's in my mind. But if I said August, that was a misstatement. You know what I was thinking of? Another big trial that's set to start in August. Koberger. Jury selection, I believe, starts July 30th or 31st. And then, that trial is scheduled to start, if I'm not mistaken, on August 11th. So...
Wow.
Oh, look at this. I love this. See, to all the people, all the haters out there, Maria Benkstrom said, if judges and lawyers were more like Andrew Myers, Massachusetts would have a better judicial system. I'm not sure everybody would agree with that, especially 9 people sitting up in the court in Boston, but thank you for the nice words.
Wow.
Let's see. Oh, and by the way, our background that you really can't see because of the background building there, that's the John Adams Courthouse in Boston. It houses a lot of the Boston courts. And there's to the right, as we're looking at this, is a very tall building where the Massachusetts Supreme Judicial Court sits. So this ruling came out of that building. And yes, I took that picture one summer day. I was working.
It looks like Bettero's going to be on YouTube. He can still be on YouTube even though he's signing on.
What channel is he going to be on?
It says, Della Sandor says, Bedro on Young Jerks soon at 6 p.m.
I'll have to catch that. Look at this. Yolie, people love you too. Oh, wait, did you just enter a comment? Because it says here, Twizzle Sticks says Yolie.
Yeah, I know Twizzle Stick.
Twizzles is a frequent commenter.
Yeah, on mine too.
Here we go. Clerk Jim Clown. Who's he? Thanks, Andrew, Yolie, Laney. Judges seem to get away with this bias, like in Delphi. I also see some in Idaho. Is there not a system to monitor stuff like this? But
I can't fill the shoes of Laney, but that's okay. I can help. I can't fill Laney's shoes, but
we love having you. You're unique in your perceptive legal analysis. Yay to Mark Bettero.
I never watched him. I've never seen him talk about the Karen Reed case.
He's Turtle Boy's attorney.
Oh, because I didn't follow Turtle Boy. That's right. I got into Karen Reed because of you.
Remember? I remember that. Yeah. We were doing Koberger, and we got a little bit burned out on Koberger. So I said, "Are you following this?" And yeah,
I said no. And then we did a question and answer session on one of your shows, and I was like, "What?"
Yeah, but did I give all the right answers?
You might have made a mistake here or two.
No, me
with a minor fact. A minor fact you might have.
But we have a feature when we do our regular episodes. The number of countries that are following this case through our comment section, it is now up to 48. We've had comments from people in 48 countries, which I think is amazing. I mean, you expect it in Massachusetts, you expect it in New Hampshire, because people get mad at me, but I say Southern New Hampshire anyhow. It's just a suburb of Boston. So yeah, we expect it here in New England. Rhode Island is part of the Boston media market. So we expected it from the 6 New England states, but we started getting comments from Wales and Australia and New Zealand. So I started keeping track. So ever since I started keeping track, maybe 3 months ago, we have comments from 48 countries.
Oh.
All right.
Oh.
So I guess we should wind down. Yeah, people are talking about Bob Alessi. They like him. Mr. Bettero is going to be on a podcast tonight. Well, he's not in yet. That petition pro hoc vice hasn't been allowed yet. Plus, also, there's no non-dissemination order in this case.
That's right. I keep thinking of Koberger, because there's a non-dissemination order.
Yeah,
that's right.
This chat has been the best ever.
Good.
Della Sanders says, Bettero is so eloquent, smart, and never says anything bad about any attorney or judge. That's true. And I try to be like that. I don't like people name calling. I really don't like the names, and everybody has a name, and I won't name call, and I don't like people to name call. And I found that Mr. Bettero is a gentleman because he doesn't. He just calls balls and strikes and comments about legality with some jokes in between. A genuine great guy. Yeah, I would agree with that. So adding Bettero is like the Warriors adding Durant in 2016. I'm not a big football person, so I don't know what that means. Kate, we love you too. Andrew and Yolie. Antonio Correa. Andrew, you're the man. Thanks for your insight. All right. I guess it's time to kind of wind it up unless you have any closing thoughts for us.
No, I have to get back to work.
Yeah, you and me both. I got to finish. I got to clean off all these papers from the conference room table and see if I can write something coherent between now and Thursday. So, Yolie, thank you for joining me. I mean, it was a dirty trick I played on you to call you at the last minute and say, hey, but it went well. Thank you. Thank you so much. Mm-hmm. I wish you all the best. Be well out there in California. So.
Okay. Well, till the next time.
Okay. Be well. Take care.
Bye, everybody.
Bye.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.